This meeting will be called to order by me, Lawrence Serpin, at 10:02 a.m. on Wednesday, May 30th. I wanted to welcome all the board members in the room and the audience watching at home via the live stream. And I will hand it over to the wonderful Michelle Phillips.
Meetings of the Industrial Hemp Advisory Board are open to the public and comply to the Bagley-Keene Open Meeting Act. This act allows for the public to comment on all agenda items. Audience members may address the board following each agenda item. Please step up and use the microphone at the podium when doing so. All speakers from the audience are limited to 3 minutes to make sure everyone who wishes to comment have an opportunity to do so. Are there any members of the audience that require accommodation in order to participate in this meeting today? Okay. Please, if you haven't already done so, please sign in. It is not mandatory for attendees to sign in to participate in this public meeting. It's simply to help out with minutes and with communication to interested parties.
All right, we'll begin with a quick roll call of all the board members. Just briefly state your name and who you are, what you do. My name is Lawrence Serpin. I'm the owner of Hemp Traders, and I'm also on the board of directors of the Hemp Industries Association.
Matt McLean, CEO and founder of Recreator Hemp Clothing.
Rick Garola, Tehama County Agricultural Commissioner.
Valerie Milano, Plant Science Department, Cal Poly Pomona.
Van Butzik, Cooperative Extension Specialist, UC Berkeley.
John Rulak, founder of Nativa.
Dave Robinson, Sheriff, Kings County, representing the California State Sheriff's Association.
Richard Soria, a retired horticulture teacher from Cabrillo College and a pest control advisor.
Joshua Kress, I'm the program manager for the Nursery Seed and Cotton program here at CDFA.
Michelle Phillips, senior environmental scientist with Nursery Seed and Cotton, CDFA.
All right, thank you everyone for being here today. Each board member should have a personalized folder with the handouts. Copies of the agenda are available for audience members. All handouts will be brought up on the screen, and copies can be provided after the meeting upon request. All right, if you could, board members, briefly review the agenda, and we'll see if there's any changes. The two exciting topics that we have for today will be Senate Bill 1409, led by the Legislative Task Force. They will be giving the recommendations. And we will also be discussing the registration fee structure led by the Registration Fee Task Force. Does anyone want to make any corrections to that?
Okay, well, let's quickly go over the restrooms, emergency exits, so forth. If you need to use the restroom, please go out, take a left, and on the right-hand side, the first two doors are the men's bathroom, and the women's is around the corner, or if you go straight down the hallway up the stairways, there's another restroom there. Drinking fountains are available on the left-hand side across from the men's bathroom. We have water bottles out in the back of the room. Please let us know if we run out of any. Also, for emergencies, please exit and go back out to the front and go across to the park, and we'll reconvene there. Okay, and then there's no scheduled breaks on the agenda, but we will take a break approximately every hour as needed or requested. And then quick note for board members, please make sure to make your car rentals and your flight reservations through Kathy. Also make sure to forward any travel receipts for her, to her for processing.
All right, to the audience members, we will have opportunities for public comments throughout the meeting, as well as general comments at the end of the meeting. For comments during an agenda item or pending board motion, please keep your comments pertinent to the item motion at hand. At the end of the meeting, we will have opportunities for additional comments, both related to the meeting and for items not on the agenda. We request all individuals who would like to comment on an agenda item to come up to the podium over here and use a microphone. We will also request each speaker to state their name and affiliation before commenting. We have a large number of attendees, although not quite so much this time around. If we run out of time or we're limited, we'll be limiting the comments to 3 minutes unless there are follow-up questions from the board. We will be timing all commenters and will try to provide a warning prior to the time limit ending. Thank you for your consideration as we try to provide everyone with an opportunity to comment on the proceedings. If you have additional questions for the CDFA regarding industrial hemp and the industrial hemp program, please direct your questions to the CDFA staff. You may contact them by emailing industrialhemp@cda.ca.gov or calling 916-654-0435. Right, any questions? Okay, we have the first item on the agenda is our legislative task force, and that was will be headed up by Matt McLean and Valerie Milano, who have been working all week to come up with some recommendations for the current legislation. So I'll hand it over to Matt and Valerie. Please take it.
Podium.
Before we begin, Matt, Tom, who just came in right now, would you really quickly just state your name and introduce yourself?
Tom Pierce, manager of West Island Cotton Growers, a cooperative, farmer-owned cooperative in the San Joaquin Valley.
Thank you. Go ahead, Matt.
Alrighty, there we go. So this is the latest language of SB 1409 as amended in Appropriations Committee last week. And hopefully we can go through and track some of the changes that we've been making here over the past week as far as recommendations from the Legislative Task Force. Obviously you can follow along on the screens that are provided. The kind of overview up top here includes some of the amendments to sections of the Food and Agricultural Code. We're recommending adding a section 81012, which will further clarify below. This is just the General Legislative Council's digest. I don't think there's really much that we've made in terms of edits or additions there. As you'll see, the red strike through and the dark blue amendments are from the Appropriations Committee and not from the board. Those are available online, so I don't know if we'll need to digress into those much. The short note here refers to that added section, and obviously, you know, everything in here is up for debate and discussion within the board, but previous legislative bills and acts have not included Native peoples or Indian tribes in the industrial hemp language, so we're hoping to include those peoples in the language of SB 1409 and clarify their cultivation and processing permitting and possibilities there. As we get into the bill text below, we'll start here with section 81002. This is a note from Valerie.
So we added a section here with some language about clonal propagators and we said clonal propagation of approved seed cultivars may also be grown without further review as they are genetically identical to the parent cultivars that will exhibit identical characteristics when grown. So we just wanted to get some language in there about clonal cultivation.
Yeah, because everything previously was referring to certified seed. Don't think there's anything else in section 1. Section 2, in hopes of providing some more data for an agricultural pilot program, we're requesting to include information about the state or country of origin for the cultivar, as well as in 2B here as well. Changing the registration period from 2 years to 1 year, so it goes along with the plant and seeding and harvesting schedule there. Again, these changes are from Appropriations Committee. There's a note from you there, Val.
Okay, we also brought up the point that we need to differentiate between seed breeders and seed producers because they aren't necessarily the same thing.
And again, this is in the seed breeders section here. Again, we're just requesting that the state or country of origin be stated, as well as changing the permitting period from 2 years to 1 year.
Can you explain that a little bit more? You're saying the registration process or something else from 2 years to 1 year?
Yeah, the registration process, I think in the language of SB 566, it identifies 2 years as the period of registration, which for, a pilot program for a plant that hasn't been grown in the state, for a grower to have to shell out $1,000 for 2 years doesn't make as much sense. There might be a lot of changes in their application or where they want to grow. I think it just makes more sense for 1 year to be the stated period of the permit or the registration. Let's see, section 4, again, these are Appropriations Committee changes, and a lot of it's about the fee collection and how that will get dispersed and kind of the kickback to the CDFA. We can review that if we think it needs changing or additions, particularly Rick, if you see some problems with the language there, we can discuss. Section 5 here, 81006. We're hoping to remove the densely planted language from the bill as it's not defined previously, and since clandestine growing is prohibited, we don't really see the reason to have that language included. We're getting to a pretty heavy section of changes here. This is mostly around the sampling and testing. And a lot of these recommendations come from the testing task force that Richard and Allison headed up. Particularly the things that are highlighted are kind of very detailed. Not sure if we need to go into that much detail in the bill or if we can cover it through the regulations process. But we tried to mimic as much of the language that was recommended by Allison and Richard as far as the sampling. So for timeline, they'd recommended that it happens no more than 30 days prior to harvest. In terms of what we're actually sampling, the recommendation was that the sample shall be taken randomly with the grower or seed breeder present, and at least 5 random samples from different plants shall be taken per variety to be milled and combined into one sample. These samples shall include stalk, stems, leaves, seeds, and fruit-bearing part of the plant, or any parts intended to be included in an extraction process. Indoor and outdoor growing areas should be treated as separate crops, even if they're the same variety.
Matt, I just have a quick question. What page number are you on? we're having a hard time.
In the handout that you have, it's just the amended copy from the Appropriations Committee, so these,
Oh, we
Page
don't
9.
have this. Okay.
yeah,
Yeah,
these,
right now he's looking at the language, it's on page 9.
so these changes aren't actually in your paper copy there yet. They will be available for handout.
Okay.
Point 3 here, the sample collected, we've identified some of the protocol there, whether it needs to be included in the actual bill or not, up for discussion, but that the sample should be placed in a brown paper bag, or I think breathable bag was the other language, kept in a cool area marked with properly labeled chain of custody to include the seed breeder or grower's signature, and accompanied by the following documentation. On point 4, it was recommended that the laboratory testing should be performed by gas chromatography with a flame ionization detector. Again, whether we need to include that in the bill or it's better for regulations, it's up to us. On a dry weight basis was included to match federal language. And for the purpose of retesting, adding when the registrant will be notified if the pass or fail of the pass or fail test, that they have the opportunity to submit another test if they're between the 0.3% and 1% THC rating. For purpose of retaining the samples and retesting or confirming the THC content, the laboratory shall retain the sample for 30 days if it was between 0.3 and 1%. If it's actually, that was if it tested pass under 0.3%. If it tests between 0.3% and 1%, they should hold it for 60 days. Point 7 recommends that the registrant shall destroy their crop, but within the bill, there's no identification of how that should happen. The language that's highlighted should probably be included in regulations, but we wanted to note that we'd like to put the carbon back in the earth, whether that's by undertilling or if biochar gasification is possible, or having the county ag commissioner or the department identify other possible means of destruction, so that we're not just burning up acreage of hemp. And to give the farmer a little bit more time to take care of that, we're changing the period or recommending a change from 48 hours of destruction to 7 days. Point 8, registrant that intends to grow industrial hemp or complies with this section should not be prosecuted for the cultivation or possession of marijuana as a result of the laboratory test report that indicates a percentage content of THC greater than 0.3%. Wanted to strike does not exceed 1% language there. If someone's complying with the registration process, their intent was to grow, but maybe they got a cultivar from out of state and grew it in a high altitude, not necessarily wanting them to go to jail for that. I think that's it in section 5. I think this is a big one to discuss too. It's section 6. So the recommendation in the bill was that the CDFA may establish and carry out by regulation an agricultural pilot program to get the state more in line with section 7606 of the Federal Agricultural Act of 2014. And our recommendation is that each registrant is actually a participant in the CDFA Industrial Hemp Agricultural Pilot Program to be overseen by the board, the board's purpose is to report the economic impacts of industrial hemp cultivation, processing, and product manufacturing to the Assembly and Senate Committees on Agriculture and the Assembly and Senate Committees on Public Safety not later than Jan 1, 2019. That language is actually from SB 566. Section 7, and I think this will be another area of discussion here. Basically saying that a city or county, upon finding a pollen drift, that may pose a threat to licensed cannabis cultivators permitted in the city or county can prohibit growers from conducting or otherwise limit growers' conduct of industrial hemp cultivation in the city or county by local ordinance. In the language, this includes growers who meet or do not meet or exempt from requirements for registration. And I think the concern here is that, you know, a city or county or local governance could tell an institute of higher education such as UC Davis that they can't grow because of cross-pollination concerns. So I know there's probably some members in the audience that have some ideas on that, and we should also discuss it amongst the board.
Do you have any specific recommendation for that?
It's a real sticky kind of situation. I think it's about a specific finding related to pollen drift, and the language of it may pose a threat. Like, I think everyone's aware that it may pose a threat, so the burden of proof is, I think, on the local governance and whether they can prove that it does pose a threat. And really the concern on my behalf is that, again, a land grant university is going to be denied a pilot program by a city or county because there's licensed cannabis cultivators in the area. So there's a right to farm consideration there. Section 8 just kind of widens the definition of industrial hemp in the California Controlled Substance Act. And then this last section that we referred to above is trying to add some inclusive language for Native peoples or Indian tribes that mirrors proposed legislation at the federal level, but also creates some sort of dialogue with federal law, section 7606 of the 2014 Farm Bill. So proposed changes here or additions would be an Indian tribe desiring to cultivate or process industrial hemp shall have two options. They can operate as a whole under regulations and exemptions similar to the standing of an established agricultural institute in the state, or they can have individual tribe members apply as a registrant grower or seed breeders with the county or department officials. Secondly, the board and the department shall coordinate with tribal government to enact procedures for compliance with section 7606 and any unforeseen changes to federal law. And then the third request would be that the department increases the size of the Industrial Hemp Advisory Board to 12 members, and that additional member seat shall be a representative of Indian tribes in the state. And that's basically what we have in terms of edits, additions, recommendations. So if there's any particular notes or points that we want to discuss, we can kind of go back to that section.
All right, yeah, I have a few questions. Do you want to say something, Valerie?
No, I think, just to reiterate that the pilot program is really important here, and a lot of the comments that we made and changes that we recommended are geared toward gathering data, which a pilot program should do. For instance, having people sign up every year instead of every 2 years, and that sort of thing will probably help that process. So we are trying to make this a data gathering effort as well, and also requiring that someone who signs up for this program is automatically enrolled in the program, so that we can track activities and find out what's the best for this industry. So these items that we have brought up are definitely up for discussion. And if anybody has any comments or questions about it, we'll do our best to answer, and maybe we have no answers for them, I'm not sure, but we'll give it our best try.
All right, Matt, anything else you want to add?
No, I think that's it from us.
All right, I'll begin with a few of the questions, although I'm not positive if you guys can answer that, because I'm getting a lot of phone calls and emails from the public with certain concerns about the changes in the law, even things that were just amended, I think, a week ago on the 25th. So the three that come to mind, or the two that come to mind, one is any excessive fees that might come up. The state will have their own fee for issuing the registration, and then the counties could have their own fees, and there's a concern that they'll start treating industrial hemp like recreational marijuana they'll kind of look at the whole CBD aspect of it, consider it recreational marijuana, and then all of a sudden they'll put on additional fees that are more in line with recreational marijuana, and it would make it impossible for any regular farmer to be able to grow it for industrial purposes. I was wondering if you guys had any comments on that.
I think the second task force is going to respond to that. Am I correct? That's item number 3 on our agenda, the registration fee task force report.
I think we can discuss it now. I mean, the question is about the pending legislation, so if the board has concerns with pending legislation, I think it'd be good to have that discussion. So, I mean, I can open that up to whoever wants.
Within the language of the bill, is there the possibility of the local governments adding fees? Do you see that in SB 1409? Is that?
Yeah, if you want to scroll up.
I think that's some of the amended language, right, from?
Correct. Stop right there.
You're right here.
Yep. So if you look at the new subsection C, which was added to section 81005 of the Food and Ag Code, it states, and I can read it off real quick, just so we're all on the same page. The Board of Supervisors of a county may establish a reasonable fee in an amount necessary to cover the actual costs of the commissioner and the county of implementing, administering, and enforcing the provisions of this division, except for the costs that are otherwise reimbursed pursuant to subdivision B, to be charged and collected by the commissioner upon registration or renewals required pursuant to sections 81003 or 81004, and retained by the commissioner or county as appropriate. So yes, that would allow the county Board of Supervisors to establish their own local county fee to be able to recover their costs, because currently that is a concern, is the ability to recover, for the counties to actually recover their costs for doing the work, since it is a local registration.
Right, and some costs are going to be higher in one county versus another, depending upon the infrastructure and how many farmers there are.
I want to ask a question on that. I think you were mentioning the language said they can add a fee to cover their costs. That would be only it. They cannot necessarily add fees to try to increase the tax base.
Yeah, it says in the language, in an amount necessary to cover the actual costs of the commissioner and the county of implementing, administering, and enforcing this division, which is the same language that's above, or similar language to what's above for the department itself.
Thank you, Josh. All right, does any other board member have a comment on this specific topic of this specific topic?
Just real quick, Lawrence. You know, from the county perspective, the way fees work is, you know, the language is pretty specific, so the county's not making money on it is really what it comes down to. And I just want to clarify that for everybody in the audience. This isn't about the county making money. This is simply only covering those costs, and how it works annually is you review those fees that you charge out to the public, and you have to justify through your hourly wages and your budget on what those fees should be. And so it should keep them pretty reasonable.
All right, thank you for that clarification, David. Anyone else have a question or comment on that subject?
Yeah, Valerie, you were mentioning earlier the pilot. I haven't looked at this, but the pilot program, does that, when is this pilot program going to get started? And is there a limitation on acreage in a pilot program?
So the pilot program is written into this. It's section 6 at this point in time. Let's see. We have a January 1st, 2019 date here. But I believe the time that the program would actually start and be implemented is not totally defined yet. I mean, I don't believe there's a limited acreage at this point. We haven't defined any of that. It's just the idea of having a pilot program in keeping with the federal program and gathering data that will make it a better industry for California is what we're looking at. So I don't think you can help me on this one, Josh. There's no acreage limitation at this point in time?
No, so current and proposed laws don't have any acreage limitations other than the limitation where you have to grow above 1/10 of an acre, but there's no maximum acreage in current or proposed legislation, or current statute or proposed legislation. And then This bill, as far as it taking effect, would likely take effect January 1st of next year. So that's the normal legislative cycle, would be that if the bill passes this year, it would take effect on January 1st.
And complete specifics about what the pilot program would involve have not been completely worked out yet.
Thank you.
I had a question regarding the whole pilot program. Is this just for people who are growing it for research purposes or for a pilot program, or it would be anyone who begins to register to grow industrial hemp would be a part of it?
So we recommended that anybody who is registered to grow be part of automatically be part of the pilot program.
And would that put any other burdens or regulations or reporting requirements for any farmers that were growing?
Not as stated, no. Basically, it's rolling our current structure into a pilot program. So it's no different than the registration form or the regulations that are established in statute or that we've been discussing. Anyone who wants to register as a grower or a seed breeder would automatically be entered into the pilot program, but institutes of higher education or established agricultural institutions are not required to register, so they would not necessarily be a part of the pilot program.
So would you characterize this as more of just offering legal protections to the farmers that grow industrial hemp?
I think that's one part of it, is we want to bring the commercial growers in line with the federal language, so that there's no gray area there. And then the second would be for data collection. We want as many farmers, growers, seed breeders participating in as a pilot program so that we can collect data on different microclimates, seed varieties, and provide feedback to the public on that.
All right, any other board members have any particular questions on that topic?
I was interested in the pollen drift. Is there any information how far the pollen drift is?
Well, I think it's been debated. I've heard anywhere from 2 miles to 10 miles. I think it's some pretty wide language here, and I'm not really sure where it came from. But again, I think our consideration is on the right to farm, and it seems like the local city or county has to provide evidence that there is pollen drift happening or that there is a potential threat of pollen drift in the area, and kind of de facto then if there's not licensed cannabis cultivators in the city or county, then that shouldn't be an issue.
All right, I had another question getting into what we were just talking about, pollen drift, and the new or some amended legislation as a part of the bill. They're saying that is it a county or a city would? Either would basically restrict the growing of industrial hemp if they feel it's somehow threatening a recreational marijuana operation? That's basically what it's saying?
That seems to be how the language is geared there.
All right, and then something I'm not exactly positive about, and that is under Prop 64, is recreational marijuana grown indoors, outdoors, or both?
I think that's particular to the county.
But it is both.
Yeah,
Yeah,
there's
it can grow.
cultivation licenses for indoor and outdoor.
All right, and in your opinion, does it seem that this somehow, couldn't it go the other way around, where we could say that the recreational marijuana is affecting the industrial hemp as well, and this seems to favor more the recreational marijuana?
Yeah, but I think in terms of recreational marijuana or recreational or adult use cannabis, there's not a lot of pollen being produced. So that cross-pollination concern's not as wide as if someone's growing acreage of male plants and it's going to pollen.
And it would have a bigger impact on seed producers than just regular hemp growers
Yeah, actually, it's right, because of adult use, they're basically looking to produce non-pollinated females. is what they want. So, they would have to protect it anyway, and there's, I think, just random wild hemp pollen in the air anyway. So if anyone were to grow outdoors, there's always going to be a risk that there might be a contamination with male pollen.
This is an issue that you hear about often. I mean, this is a big concern. I don't offhand know how far the pollen drifts. I'm not really sure, but one of the other things that we have to take into consideration and maybe discuss, or it has to be dealt with, is if there's a person who's growing hemp and then a cannabis grower moves in after the fact, what happens to that person? I mean, it's who wins in that situation? Or does that even work that way? It would probably come down to a zoning situation, it looks like.
All right, and I think zoning would probably be a better idea regarding it. Okay, does anyone else have any other questions? John?
I wanted to, a couple of points. One is I want to confirm I understand the language requiring a DEA-approved lab. That's been removed, the DEA language for the lab protocol.
Yeah, that was removed in Appropriations Committee. Not sure exactly where it is. Yeah, right here, it's, now it's a laboratory approved by the department and
Okay.
state.
Okay, good. And then the other thing is I wanted to talk about the pending federal legislation and just an update for people. I just learned that we have 24 co-sponsors in the Senate, which is, I'm like, that's amazing that we're getting that much support. And I think both senators in California have not signed on to that. That's something I encourage all Californians to see if we can get our California senators. There's both senators from Oregon, both senators from Kentucky, both senators from Colorado. But
let's try to keep it. Right now, we're talking about the California legislation.
So what I want to see is if this legislation passes in the federal side, and we have, I think there is a bill that's there. Will we need cleanup language in this bill, or is there anything we can put in this language, or does it include that if the federal legislation passes, that would, as long as we fell under that? I'm just wondering, just given the industry is moving so fast, and we seem to be a little more, we're a little behind versus, Colorado and other states. Just want to see if we've thought about that, because it's likely that to pass, and it'd be, if there's an opportunity to give California growers an advantage there, and not have to fall further versus other states. I know there's some challenges there. Anyway, I just wanted to bring up if there's anything tied into the federal legislation that this bill can reference that, or is that just automatic? I don't know if you understand what I'm saying, but.
One section that we've definitely taken in the Hemp Farming Act of 2018 into consideration is the last section on Indian tribes. That's where we have any changes to federal law there. I think the proposed language of the Hemp Farming Act of 2018 gives a one-year moratorium on pilot programs after it passes. However, I don't think there's anything in how we're setting up the pilot program here that would limit farmers or growers at all. And I think it's pretty in line. I mean, part of the reason that we're adding that language of the pilot program now is to provide commercial growers with more federal protection. Because currently, if we were to register growers, one, they'd have problem getting certified seed without a DEA permit. Secondly, there's no federal protection there because they're not members of a pilot program, and so they're not actually falling under Section 7606 of the Farm Bill. So trying to work within the current statutes there, but I don't think there's anything that would preclude farmers from growing or anything that doesn't fall in line with the Hemp Farming Act of 2018 if passed.
But thanks.
All right, thank you, John. Rick, you had a question?
Yeah, and this is certainly going to need a legal opinion, but you've referenced the fact that it's a right to farm versus cannabis and hemp. And currently, and Josh, you may weigh in and may want to weigh in, but currently neither crop are recognized in California as an agricultural crop. I know cannabis is recognized as an agricultural commodity, but if federal legislation passes and possibly industrial hemp may be recognized by CDFA as a crop, that would put industrial hemp as the leader as far as being an agricultural crop that would qualify for the right to farm in most ordinances, unless the Board of Supervisors wanted to restrict that.
Yeah, I mean, I don't have any further comments on that. Yeah, it hasn't been defined as an agricultural crop in any law yet or any regulation yet. I mean, so that is something the board can discuss further, is whether they feel it should be defined either in law or in regulation. But yeah, I mean, obviously federal law would potentially define it. Yeah, I don't know.
So, just to follow up on that, would it be appropriate to say if Congress legalizes industrial hemp and removes it from Schedule 1, then this bill would, that state of California would recognize hemp as an industrial, as a food crop? Or not maybe food crop, but is there any way we could do that so if the federal government passes it, that we don't have to come back and fight over that issue?
I don't know that there's anything that prohibits doing that now, right, as far as recognizing industrial hemp as an agricultural crop. Right now, it doesn't specify at all, so it's just kind of absent. I mean, that might be something the board wants to discuss, is does the board want either law or regulation to establish that industrial hemp is an agricultural crop? Yeah, as Rick mentioned, currently cannabis is defined as an agricultural crop for the purposes of those chapters specifically. So it specifically references those sections that are regulating cannabis. Industrial hemp doesn't reference anything.
What do you think the legislators would think of having that included in this bill?
It's something I've actually discussed with Alex from the CCIA as well. I don't know how that affects grants or water rights or, versus a specialty crop designation or anything like that, to be honest.
Yeah, and as we discussed before, the only impact that I'm aware of is what relates to our programs that we already oversee, which is our seed program. So it would likely lead to us defining hemp seed as an agricultural seed in the seed law and enforcing California seed law and seed regulations on industrial hemp seed in California, which we don't currently define that. So it's outside of the scope of the seed law as far as labeling requirements and germination testing and things like that. So it would require those, but otherwise I'm not familiar with any other rules. I don't know about Rick or Dave, if you have anything else to add on that.
So maybe that's something to consider that we could add to the language or for further discussion down the road. Definitely, I think something that Alex could provide some added insight on.
All right, does anyone else have any questions from the board regarding the pending legislation?
Lawrence, two things. I'll start with the Indian tribe language. Do you know if that was vetted through a tribe that's under Public Law 280 in California? Because we actually fall under different guidelines than the rest of the nation under Public Law 280.
I do not, but the language was trying to mirror the federal language in the description of the Indian tribe, yeah.
Okay. Because I think in California, under case law, because we fall under Public Law 280, they can't be regulated under certain circumstances, and this might be one of them where they're free to do it anyway.
Right.
So.
Yeah, I think we definitely need some legal clarification on that section. It's kind of just what I came up with as I could.
Yeah, no, that sounds great. And then the other concern that I think we would see in law enforcement is the suggestion to take the plow down to 7 days. I think there should be consideration on the size of crop. If it's a 1/10 acre crop, 48 hours is plenty of time. If it's a 20,000 acre crop, I could see where 48 hours is not plenty of time. And so my suggestion there would be is it should be based on acreage size. because we wouldn't want to get into a situation where they might have a really high THC content on a very small crop, but they don't plow it down for 7 days because it's so close to being harvested.
Right.
And so I would just suggest that, you know, we got to keep that in mind, acreage size on that
Fully agree there.
suggestion.
Can I make one comment on your previous question? With regard to language about tribal groups being involved, I looked into what was going on in other states, and it's all across the board. There's all kinds of information that's really inconsistent. So I don't know how to answer your question, but there's probably 10 different ways it's being handled in 10 different states. So I think we need to probably spend a little bit more time figuring out what we would like to do with that. But we did want to include this section because we definitely want something about this in this bill.
I agree.
All right, anyone else on the board have some questions? Tom?
Yes, I just wondering whether there was any plannings this year, industrial hemp, through an MOU, through an institution overseeing the planning, and did that get done? Was there any industrial hemp planted?
I think we have a few people in the audience who might be better be able to answer that. Personally, I have heard of a few, you know, that are happening, but nothing through me directly. So when we leave the commenting open to the public, I'm sure somebody will come up and mention what might be going on at the moment.
I don't think there's any institutes of higher education that have a pilot program going, but there may be established agricultural research institutions that do.
I mean, I can speak for the department. The department is not aware of any, but the research institutions are not required to notify the department, as they're exempt from registration and exempt from that any notification requirements. So we are not aware of any.
And speaking for the CSU system, we were instructed not to, very clearly. So there's nothing going on that I know of at any of the CSU campuses.
You know, I had contact with the ag commissioners. There were just, you know, they were just pushback from them because we, you know, as this board hadn't given them enough direction or help to get that started. They brought in legal counsel, taking their advice, and everybody just scared to death to make a move. Not the farmers, they're ready to go. I've been contacted by many, many farmers and I can't tell them any, you know, I don't know.
I think of certain help is the clarifying statement from the CDFA on established agricultural research institutions.
All
and
right,
their
let's get
legality
back
there.
on topic for the legislation at hand, although that's a very good topic. We should probably talk about that in a moment. Does anyone else on the board have a question about the SB Senate Bill 1409 or for our people here? No? Okay, so now we would like to open it up to members of the audience. Is anyone in the audience wishing to have a question or comment on the pending legislation, Senate Bill 1409? Please come up to the podium, state your name, and try to keep it brief to about on point in about 3 minutes.
Good morning. Wayne Richmond, California Hemp Association Executive Director. Thank you all for being here for this board meeting today. Short but sweet. Senate Bill 1409, for our members, seems to have lots of problems. While it does seem to be there are some things in there that we can appreciate and support, there are lots of things in here that we cannot support. And this cross-pollination section that was just added in is another thing that just, quite frankly, knowing who's behind this bill makes this a cannabis bill, not a hemp bill. This is not a bill to support farmers in its current state. And we've offered up some comments and suggestions to Senator Wilk's team, and we kind of been rebuffed. And so I'd like to know if anybody here on this committee has had the opportunity to have direct input into this legislation, because it seems to be happening in a vacuum. Anybody here? So that,
I met with Senator Wilk's office, and one of the things I talked about, I didn't want the DEA lab requirement in there. But now it's gone to appropriations, and this is a bunch of new language that I haven't looked at. So So I know that they've been working with various hemp organizations on this, but this is new text that's come up that, I haven't had a chance to look at.
So one of the things that concerns me is the hemp organizations they're talking to don't seem to have a stand-up organization like ours in the state. So I'm wondering why our organization hasn't been invited to the table to have our members, or frankly, friends and associates of most of the people in these other organizations. Why haven't we been invited to the table?
I'll just comment. I mean, one of the groups I'm talking about is Vote Hemp, and they've reached out to the to the politicians. Your organization's welcome to reach out. I understand.
No, they have not. Eric Steenstra has never called me.
No, I'm saying you, as your organization, have the right to reach out to these. You haven't been shut out. You have the right to reach out to these the assembly or the senators and comment, just like any other organization has. So I don't think anybody's shutting you out there.
Well, actually, we did have some conversation, and following 1 week after the conversation where we were assured that the Agricultural Research Institution exemption would not be messed with, 1 week later it was messed with by Section 7, by the last section that they added in. And so I have to ask, for those of you, John, what about this bill makes this a hemp bill in your opinion? How does this help hemp farmers?
Well, I think it's creating some clarity. Obviously, we have rules that are very restrictive right now. One of the limitations of this is because of the bill that was passed, in the past, it has to work through that, and so we can't resolve all of the issues with this legislation. What I'm told, that's part of the legal issue and the challenges. And California does have one of the most restrictive hemp growing regulations in I think in the world, which is frustrating for me as a California hemp entrepreneur. But I think there are a lot of good points in this, and it definitely can be better. And so, I'd encourage you, if you have specific comments and section, because it is technical, to submit that to us, in writing, and we can review that and see what things can be changed. But this is just got recently updated, but it's going to streamline things in my view, and the legislative committee just recommended some of the things that they've been working on to do that. I like the idea of going into a pilot program. That's going to kind of help the legal aspects there. So it's not an easy process, this legislative process, for sure.
Yeah, I think one of your areas of concern, Wayne, is one we have up for discussion too, is that section. And if you want to scroll up on the mouse too, you can pull it up on the
Which section are you referring to?
Other way, Section 7. It's the local and city ordinance there, right there,
Okay.
and the exempt language. And again, I think we talked about the right to farm and the exemption there. I understand if they want to limit registered growers and stuff, but personally, I'm not sure where that fits with like a land-grant university or UC Davis or any established agricultural research institute.
Yeah, well, it does introduce some interesting new problems, actually, this legislation. While it helps clarify some things, I just find it to be rather lacking, and so do many of our members who have marked it up. So we do have a markup. We'd be happy to share it with you, John, and anybody else on this committee who'd like to see it. And we will be sending it over to the various supporters of this bill later on today and tomorrow, with the hopes that we will actually get something useful for our farmers. Our farmers need this crop, period. These are food and family farms. These are not pot farmers looking to switch crops. And so I hope that the focus of the people who are looking at 1409 understand that this is really supposed to be a hemp bill, not a cannabis protection bill as it now seems to be. So I'll leave the comments for that for now, and thank you for your time.
All right, thank you, Wayne. And also want to add that the whole purpose of our meeting today is so we can give recommendations to the legislature on ways to improve that bill. Go ahead, we have Chris Boucher coming up.
Good morning. My name's Chris Boucher. I represent Farmtiva, and I'm also here representing the Imperial Valley Conservation Research Center. And just to inform you, we've planted our seeds, and they're in the ground, and we are growing a research crop in Imperial Valley. We're following the rules and regulations that have been established. However, as a gentleman said, the Ag Commissioner, there's a lot of confusion and there's a lot of fear involved in the counties, whether it's the Board of Supervisors, the County Ag Commissioner, and they've entered an unknown territory, and they're getting opinions from the county attorneys and so forth and so on. So they're all trying to catch up to speed on what the law really dictates and how to implement it in the county. So it's been quite restrictive, and finally we moved forward underneath the bill, and we planted the seeds. And as we had spoke earlier about this new AB 1409, and that's what I wanted to address, the Section 4.81005 in reference to the fees. And I was going to read the bill here real quick, that section. The bill would authorize a county ag commissioner or county as appropriate to retain the amount of registration or renewal fees necessary to reimburse direct costs incurred by the commission in the collection of the fee. There's no amount there. I mean, this could take weeks, months, and I figure it's going to take at least a year for the county to establish some of these fees and costs. And the bill would also authorize the county board of supervisors of a county to establish a registration or renewal fee. What is that renewal fee for the county? And to cover the costs, again, of the ag commissioner and the county implementing and administering and enforcing these provisions. Now, this is open-ended. I mean, this just completely eliminates the right to farm. I mean, this is going to take another year or so. If you're in a certain county, I don't know how many counties can fast-track this, but if you look at the normal protocols and the processes of a county of how they would have to appropriate these fees and get public input, and at the same time, as Wayne had said, that these counties are reliant, the CDFA, on a lot of the marijuana fees, so there's going to be a little conflict of interest in terms of, who comes first and where the money comes from. So really, at the end of the day, I'd recommend striking this from the bill and maybe redoing the language with set fees in place so we don't waste another year of these counties trying to actually come up. And I do understand that there are fees involved and time and energy in place. However, if you want to invest and build the infrastructure and build this program out to, tens of thousands of acres, we're going to have to eliminate some of this language. And so my recommendation is striking Section 4.8005 with the fees and maybe establishing something that's really solid and gives them some numbers that they can work from rather than bring it before the public and voting on it. And also, real quick, on Section 7 with the pollen drift. Now, with industrial hemp farming, there's a lot of breeding going on, feminized seeds and feminized plants, where an industrial hemp farmer might not want a industrial hemp fiber farmer down the road, or vice versa, or a marijuana grower, medical marijuana, near an industrial hemp field. So this pollen drift, again, is going to boil down to, how much of the fees that the county is getting from the marijuana people versus the hemp people. And if they see any type of, problem that might hurt their cash flow stream from the marijuana groups, they're definitely going to ban this. So it's going to be like called a ban-a-palooza almost. But, and again, it destroys the right to farm, and which brings it back to the CDFA establishing that hemp is an agricultural crop and a commodity. And thank you for your time.
Hey, I wanted to have a question for Chris. On your first point regarding the concern about the fees and, potentially those fees could get high for, the potential theoretical enforcement issues. I think it may not be reasonable, though, to strike it out. So I want to ask you as a potential compromise, what about, and also this to the board as well, what about as a proposal where that the county can, that there's a set fee, or the county can set a reasonable fee based on costs, and that would need to be announced by, let's say, March 1st, 2019, or let's say every year thereafter on, as one way, that way they either know they're gonna either get a set fee, whatever we might think about, $500 or whatever that would be reasonable, or then they can raise it, but they need to do it in a specific time and in a manner that works. What do you think? You think that would address some of those things?
Yes, I think that could be a compromise to the farmers and to initiating the program, setting up a set fee through this committee here. And if there is fees that might be incurred above and beyond that, then, as you said, they could maybe vote on that. However, from what I've heard, they're gonna, they want to definitely tax or put heavier fees on the CBD growers versus the fiber growers versus the grain growers. So it really depends on what type of industrial hemp crop you're growing. But yes, I think if that language was inserted somehow where the set fees were already in place, it would help move this program forward quicker rather than, like I said, wait another year for the counties to determine, a whole price structure.
All right, thank you, Chris.
Okay, thank you.
Just one question here that's popped in my head, and if I don't say it, I'll forget. So, Matt, Valerie, on this bill, and then maybe you explain who was involved in modifying the bill from the original, the way it was.
Well, I think the changes in red and blue are from the Senate Appropriations Committee, which met last week. The changes in purple are Valerie and I's recommendations. And then, as far as I know, the sponsors or the kind of lobbying groups behind it are Ojai Energetics and Vote Hemp.
Seems like it'd be kind of nice to have some, maybe ag commissioner or farmer, or this gentleman here, somebody like that to we're talking about streamlining and trying to get the bill where it will work.
Yeah, I think that there's some areas of dialogue. California is unique because we have the local governance of the county ag commissioners as opposed to, say, Colorado's industrial hemp program. There needs to be some dialogue with the state and the county officials at that level. And I also think that the industrial hemp program is unique compared to the cannabis program here because at the state level there's set fees for cannabis cultivation, and those, to my knowledge, don't change per county. But yeah, that's the proposed language.
I got a call from a gentleman in, I think it was North Carolina this weekend, and he asked if we'd be open to, they've been through this process, and I think we talked about it, looking at other states and seeing what they're doing, and I don't know, it just seems like we could get some help from this gentleman or anybody, any other state that has been in, and is growing, Kentucky and North Carolina and Colorado and whatnot.
I think there's a couple sections of contention here and that are up for dialogue, and to me they're really specific to California. Again, this is between local governance, city and counties, versus what the CDFA is going to do at the state level. And personally, I don't see a lot of problem with that. I know that there's different interests in terms of collecting taxes from cannabis growers versus industrial hemp farmers, but it's going to be up to the city or the county where they see that money coming in, how they want to move forward. I think naturally that there's going to be counties that greenlight hemp, and those are probably the counties that have banned outdoor cultivation of cannabis. And there's no cross-pollination concern there. Obviously it's not advantageous to a hemp farmer if you live in Humboldt or Mendocino County or perhaps even San Diego. But yeah, there's definitely some areas that need clarification, including, I think, one of the solutions would be to have hemp named an agricultural crop or commodity, and that would clarify some of these issues with right to farm.
Yes, and pollen drift, real quick. In Colorado, they've measured pollen drift anywhere from 40 to 80 miles. So, and that's on the open plains, so it does have the propensity to drift quite a bit. So it could put a burden on some of the agricultural communities that want to grow hemp, and just something to think about.
And to me, that's not very clearly defined within the bill either. You know, whether it may pose a threat or it does pose a threat, you know, how does their specific finding come about? And I think if we look at Pueblo County, Colorado, there's been ongoing issues with this.
Lawrence, I'd like to offer a comment to what Tom said and then also answer part of the question that Wayne had brought up. So the California Agricultural Commissioners Association did reach out to the author's office through our legislative advocate, and we're specifically asking for language that for our involvement, we need cost recovery. So we have reached out. That's the provision that we need to have in there for our involvement, for our time that's put into this program.
Oh, and I agree 100%. It's just we should probably find a set standard fee that would make everyone happy and at least set up some type of program initially before.
And there may be an alternative to that, because I don't know until we know the entire scope of work. We can't put a number on this because it's going to vary for the amount of time and travel. I do have a recommendation to look at when we get into that, but it's just there's no way to come up with a set number that'll fit all 58 counties.
Understand. Thank you.
All right, we have another member of the audience who would like to make comments.
Hi, thank you. My name's Brian Webster. I am a hemp business development professional and a hemp business community organizer and a member of the California Hemp Association. I have a couple of comments and then a question regarding the pilot program. So I was very surprised to hear John say that the California hemp legislation is the most restrictive in the country. So I think our goal should be to get it to be the least restrictive in the country, you know, year after year, whatever it takes. The other thing that was kind of shocking to me to just find out was that industrial hemp is not recognized as an agricultural crop. So I would say that the primary recommendation from this committee regarding the legislation is that a one sentence be inserted into legislation that says industrial hemp is recognized as a California industrial crop. I think that's all it takes, is one sentence. And then that will provide a basis for the right to farm. And that's what farmers need. All of this is happening in the context of the federal policy, which is of two minds. One is Senator Mitch McConnell. People pushing the Farm Bill are promoting the good jobs and revenue and economic development of hemp. The other is the DEA that is doing everything it can to throw up loops and roadblocks and slow down industrial hemp in the United States. And so in terms of this language, I would definitely suggest that we drop any language giving counties or cities the ability to ban growing hemp. So Riverside County has banned growing hemp. Why? Who knows? It's, basically, fear and ignorance, because there's nothing, hemp is not radioactive, it's like carrots or corn. We're just going through all this process because of the federal government and the DEA, which has it scheduled as the same thing as heroin, as a Schedule I drug. So I would also say that, marijuana is banned in half of the counties in California. So we should remove anything that encourages counties to ban hemp growing. It's already banned marijuana growing in half the county. So we should have no language in a piece of legislation encouraging counties to interfere with the right to farm. And we should establish the right to farm with this one sentence recognizing hemp as an agricultural crop in California. Now, also, I mean, local cities should have to provide evidence or a case study on pollen drift. They should have to state the facts, not some urban myth, not whether it's 1 mile or 5 miles or 10 miles or 80 miles. They should have to state the facts, the reason why, they want to ban it, and we should not, encourage them by saying you can ban it based on pollen drift, which has been introduced into the bill, I believe, by the California Growers Association, which is the marijuana lobby here in California. My question is regarding the pilot program. So hemp farmers, they know that they need to register with their county, and we don't know when that's going to happen. We were thinking September, now we're hearing January 2019. Now we're hearing, the counties may slow that down to March, which is, not a good thing. My question is on the pilot program. Does the pilot program act as an established research institution? So when farmers register, they become part of the state pilot program, and then they do not have to search and find out some established research institution to partner with in order to just, plant hemp like they plant hay in California?
In part, yes. The 2014 Farm Bill recognizes an agricultural pilot program as an entity such as an Institute of Higher Education or a State Department of Agriculture. So basically, we would be attempting to roll any registrant into a CDFA pilot program, which on our end with the board won't require much in terms of additional regulations than the registration form that we're already considering. Currently, commercial growers in California would not have any protection at the federal level because they're not participants in a pilot program unless they have an MOU with an Institute of Higher Education. However, there's none growing in the state. The date of Jan 1, 2019 is just in reference to the report that is due to the Assembly and Senate committees, not in terms of the implementation of a pilot program, although, as Josh says, if SB 1409 gets passed, it wouldn't probably go in effect till Jan 1, 2019. And to be honest, there's nothing precluding the CDFA currently from beginning a pilot program. If you look to the AG's opinion, they're able to, they're not required to.
So, well, my question is, you're a farmer. You fill out the form, you register, you pay your $1,000, whatever the fee is, right? You locate some seed that you can use. Do you have to locate a research institution, or can you, by right of being part of the state pilot program, will the state have its relationship with the research institution, thereby relieving the farmers of the burden of having to individually find a research institution to be associated with?
Well, the state wouldn't be required to have a relationship with an Institute of Higher Education because under the 2014 Farm Bill, the State Department of Agriculture is already included in an agricultural pilot program. It's one or the other. It doesn't have to be both. So the intention there is as you register, you become a participant in the CDFA's pilot program. And in terms of acquiring seed, that should help commercial growers in acquiring a certified seed cultivar.
Okay, but you don't, if you're registered, you're part of the pilot program, you don't have to find a research institution. It's built in with your relationship with the state.
That's the intention, yes.
Okay, good, that's a good thing. Okay, so, my main thing is, you should definitely have this, one sentence in there recognizing, that seems to be the primary thing. Establishing the right, the right to farm, and then farmers can sue their counties.
Right.
Farmers can, tie up their counties. If the counties are burdensome, unreasonable, whatever, they can exercise their
We need
rights.
to kind of move it along. I mean, thank you, Brian, for your comments. We have one more comment, I believe, from Alex.
Hello, hi everyone, Alex Brandt-Sawadsky here. Just for everyone in the room who has concerns, I spoke very briefly last week with Senator Wilk's office, and they assured me that, yes, in fact, the bill, S-1409, still has to work its way through the State House. And so there's plenty of time for any changes. If you have any concerns, you have every right as a private citizen, as the leader of an representative of an organization, to get in touch with your state representative. You can call them and voice your opinion. You can set up a meeting, and they will most likely have some staffer there to talk to you. That's how our government works, and I would just recommend that as a way to make sure that your concerns are addressed if you feel like they're not being addressed. And thank you all for your work.
Thank you, Alex. We have some more people on a comment, and once again, we try to keep it to about 3 minutes.
Just quick comments on the 1409, and then a couple brief questions. My name is Justin Eve. I am a USDA certified organic farmer here in Sutter County. The company I represent is 7 Generations Producers. We're focused on introduction of new cash crops and farming practices for the changing future. So a couple comments to the 1409. Matt and Valerie, you guys did a great job, I think, so thank you for spending the time to do that. No, it's not easy. The comment on the 1409 is the moisture content. There's a comment about dry weight, maybe just defining moisture content, and then the storage of that material afterwards. Definitely needs to be dry. If you store it in a brown paper bag, wet plant material in a brown paper bag for multiple months is definitely going to rot, and you won't have much there to ever look at again other than mold. And other than that, maybe a glass jar, that might help. That's an actual true dry weight, whatever that's determined. I'm sure there's people that can figure that out. Maybe the Ag Commissioner, Rick, you can kind of comment on the moisture content of agriculture crops, where they should be. In any case, and then the THC content, you're saying 1%. Oregon passed a law, it's 5%. There's one state north of us, and then Nevada, they've done a really good job. Maybe Rick, I think you'd probably be closest to Nevada. They're an industrial state like we are, an industrial agriculture state like we are for the most part. I mean, they do have a lot of that going on, and I think that you would find some good help there. Talking to the guys in Nevada, what kind of burden they're dealing with, checking crops and things like that. I think you have good success there. And if you need any assistance with that, feel free to reach out. I submitted my information before, and we can connect you with the ag commissioners there. No problem. Anybody else too, any questions there? Love to do that for you. Those are my 2 comments, or a few comments on the legislation there. Obviously, we're trying to make it easier, not harder. It's a big deal for us, and we can do well as farmers to make some money here. And the other comment that I have on there is the about any other legislation going on. From my understanding, there is other legislation going on other than 1409. So I don't know if anybody knows about that, if there's any other hemp legislation going on in California at all, or in the nation, obviously, that affects this. I'm not sure if GV Ayers is in the room, but maybe he could comment. I know he's been looking into that. But definitely the federal issue. My only question, I guess, to that is if the Farm Bill of 2018-2019 passes, and they do put something in there in hemp, essentially is this null and void? I mean, it's a federal regulation, it gets re-regulated, and then you guys are still gonna regulate it, but the actual legislation for federal farm bill will redefine hemp potentially, and then your job as a board would just be to deal with the regulation moving forward, but that would redefine a lot of the things in this legislation. Is that correct, Matt? The federal farm bill could essentially change everything and then give you a different job of how to regulate it, and this legislation wouldn't really hold to?
Well, we took the Hemp Farming Act of 2018 into consideration here. I don't think there's anything that would really need to get reworked. I mean, the only issue there that I saw is the repealing or a moratorium on agricultural pilot programs. But what we're trying to do here is get the agricultural pilot program in line with our general CDFA registration. So that's not like there's one or the other, they're one and the same. And then regarding your questions about dry weight and the brown paper bag, that was mostly like very detailed from our task force on testing, and we can consider pulling that language out and putting it in regulations instead of having it in the bill itself. And regarding additional industrial hemp or cannabis legislation, the only thing I see is AB 710, which revolves around CBD, but it's based upon federal rescheduling.
Most definitely. And then, I just had the other question about the federal farm bill. Would that change much in this? I mean, would we, if this legislation went through all the way, and then the federal farm bill came out, how would that affect that?
Well, in the Hemp Farming Act of 2018, it still requires state departments of agriculture to regulate their programs, put forth procedural regulations, have some sort of registration form. It's pretty broad. I don't think there's any conflict there.
Most definitely. Thanks for your time.
All right, yeah, we need to move forward, so one more question. Please try to keep it to about 3 minutes.
Hi, my name is Chris Hughes. I'm from Stanislaus County. I'm wondering, when it comes to licensing the manufacturing facilities, have you guys got timelines on how that's going to work? And as far as when are you guys going to be having the paperwork ready? Because I talked to my ag commissioner yesterday, and they're all for it as soon as you guys have the registration. When do you guys expect the timeline for opening to be?
Well, our next item on the agenda will be talking about the registration, so we'll get to that in a minute. And I was wondering, what was your first question?
Manufacturing, are you guys going to be the regulatory agency that oversees the manufacturing process? Is that correct?
I don't think there's anything in the bill about that, Josh.
Yeah, no, there's nothing in existing California law about overseeing manufacturing. So we don't currently have any rules or regulations on that.
Okay, thank you.
We have one more comment.
Very briefly. G.V. Ayers with Gentle Rivers Consulting. Thank you, Valerie and Matt, for the work you did. You did put a lot of time, a lot of work in it on that. A couple of questions here, or observations, actually on the section that's up there that's barely regarding the research program and the report. Pardon? Oh, okay. I have the power since I'm here, right? Okay. The language requires the report no later than January 1, 2019. You may need to look at that because that's when the bill becomes effective. I think you referred to that a little while ago. So that might be difficult for CDFA to have a report, a quantitative report from the industry that reflects industry practices by then. So that may be a difficult thing. And then, obviously, there's been a lot of concern that's been voiced about fees and such as that. By changing that may to a shall, that would arguably increase fees a lot because you're going to have because now instead of just authorizing a pilot program, you're requiring a pilot program, which costs money, and which would have to be reflected in when it goes through assembly appropriations. Obviously, that's going to have to be taken in consideration. And then the fees, which CDFA establishes by regulation for the counties to collect, are the fees to administer the program, the industrial hemp program, which now this becomes part of that. So it's the balloon that keeps filling in that sense there. But anyway, very good. Y'all did a good job. Y'all did a good job on that. And obviously, there may be some other things that we could talk about, but anyway, that's all I'll say right now.
All right, I know you're sitting there. We kind of need to move forward. We've already.
I was going to comment, follow up on Tom's question about the existing agricultural research institution programs, but I can save that for
Yeah, we need to move forward. All right, does anyone on the board want to make any motion regarding this agenda item at this time? No? Okay, so.
I don't know if this is a motion, but it does seem like this idea of agricultural crop is something we need to consider. I don't know what that means, so I don't know if there's, if we want to form another task force to see what that would mean, or if somebody can tell us what that means. Just because it seems like it's important to our growers, yet I don't feel comfortable making recommendations because it's not clear to me what that would mean long-term to the industry.
Or Josh, if I could chime in real quick. In the Prop 64 language, it talks about hemp being an agricultural crop and that it's going to be established as an agricultural crop. Maybe we could just have somebody take a look at the, voluminous Prop 64 language, because it may have been actually already dealt with through the actual language in the law. Because it specifically talks about hemp establishing it as an agricultural crop.
Yeah, it's something you might want to take a further look at and maybe come back at the next meeting and have a brief discussion on what the impacts would be as far as whether it needs to be further defined and what the impacts would be of further defining it.
All right, any other questions or comments? All right, why don't we take a quick 10-minute break and then we'll get on to our next item on the agenda. So let's see, it is 11:27. How about we'll be back here about 11:40. All right, everyone, we got to get going now. Are all the board members here? Yeah? Valerie left? Okay.
Yeah, she had a flight to catch.
All right, now the next item on the agenda is the registration fee task force report from Rick Arola and David Robinson. So would you gentlemen please give us your report?
Rick, you want to kick it off? You want me to?
You got the mic, go ahead, no.
Right. So Rick and I spoke and discussed this, and not trying to beat a dead horse about all the other discussion that's taken place today. But SB 1409 is really going to dictate a lot of what the fees are going to be. And just like the last speaker said about the appropriations and what they see, whether it's a shall or it's a may, as far as what the fees we could recommend that the state charge. And then at the local level, we can see in 1409, if this passes, it's going to be left to the local level. That's been part of the problem is that it wasn't very clear, and that's why they have the cleanup bill. And so there's really no recommendation that we really came up with as far as being able to say, hey, yeah, let's set this fee, because we're just in limbo right now. We don't like it, but we're just in limbo, because if we set a fee, we're only making a recommendation to CDFA on what they should charge, but it doesn't do anything to the local governments and no cost recovery. And so we're kind of at a standstill with the fee until we see how SB 1409 plays out. However, I would suggest that if you read 1409, it looks like they're going to specifically carve out that the department shall establish a registration fee and appropriate renewal fee to be paid by growers of industrial hemp for commercial purposes and seed breeders. I think as an advisory board, we could make an initial recommendation, especially once we see what happens in appropriations once this gets to the assembly side. It's going to be voted on by the Senate this week to move it to the assembly, probably into an appropriations committee there, because they're at House of Origin right now this week and their deadline is Friday. And so as this moves through, we'll probably have a really good idea on what appropriations sakes the ongoing cost to the state of California will be. And that might help us establish an actual fee that we could recommend as an advisory board to CDFA. It looks like at the local level, it's going to be established by this new SB 1409, and then that would be left up to the local jurisdictions.
So additional comments, again, as I had mentioned earlier, that there's no way to set a one-time fee for all 58 counties. I was able to call up on a survey that ag commissioners and sealers had conducted last year, and of the 58 counties, we had 30 counties respond. And our hourly rates range anywhere from $42.37 an hour to $161.28 an hour for providing services. So until we have an actual defined scope of work of what the county ag commissioner, what our role and responsibility is, again, as Dave said, there's no way we can come up with a fee. I know that we're going to need to get full cost recovery for our involvement in that, but because currently in law, we're required to implement, administer, and enforce. I can't see that being a large number of hours. We have similar programs with CDFA now to where we will go out and conduct what we call field walks for certified seed for agricultural crops, and we bill actual time and mileage. And that's how I would envision this probably going forward because of the fact that there's going to be such a wide variance per county of what their actually hourly rate is. And then that would allow local growers to address their boards when the ag commissioners that are going to be able to take this program on to explain what their actual costs are and what the program hours that they're projecting this to be.
All right, John, you had some
Yeah,
questions?
yeah, just, Rick, I understand the concern from the county's perspective of not understanding how many hours it potentially, and they don't want to get in with like a set fee that would burden them. I think from the grower's perspective also, there's a concern that if it's just left to the county with no time frame or process, it could take a long time, and that would prevent growers from being able to have a pathway to grow. So what about if we, as a compromise, where we set a fee or the county establishes based on their costs, and it's either or. So it's not forcing the county. If the county wants to act on it, then they can charge that fee. But if they don't act for any reason, then there's something that's clearly established.
Well, we currently, in my county, we currently do that for certain programs now. We do have certain programs that I've gone to the Board of Supervisors and I had to present a time and motion study. We can't make money on what we do. We can't charge excess. So we have to go through county council as far as presenting what the actual program cost is. It's employee hourly rates, administration, overhead, and benefits. And then, so certain programs, we charge a fee based on that. Then we have other programs, such as I mentioned for the field walks when we do for seed certification. And that's an approved fee. And depending on the person that goes out there on that classification, it's from portal to portal as far as time from when they leave to do that inspection until they return. And then that grower gets billed that amount. And we currently do that now. So we have the capability of doing that. And then also, and there's mileage tacked onto that as well.
Yeah, so I guess what I'm proposing, I want to I was just curious what you think the county commission or county's ag commissioners would think of this if it was, let's just say, $600 or $500, or if the county thinks that that's not enough money, that they would propose, and that they would propose that. And so there's some clarity there.
So can I provide a quick point of clarification? So originally, this board had made a recommendation for a registration fee that would provide $1,000 per 2-year registration to CDFA, and then it provided the commissioners with discretion to be able to set the fee in order to be able to recover their costs. It was determined that currently, our current statute doesn't provide authority for the commissioner to be able to do that. So that's one of the things that's in this current bill that would provide the commissioners explicit authority to be able to charge their own fees to be able to recover their costs. But under current statute, it was determined that in order for the board to make a recommendation and CDFA to establish a fee, we can't delegate that authority to the commissioners. So the board would have to either establish a county fee or choose not to establish a county fee and just establish an across-the-board fee at this point. Of course, if the legislation changes, then that additional authority comes into play. But for right now, yeah, if the board wanted to make a recommendation on a fee, the board can't make the board can make a recommendation, but we can't delegate that authority on adjusting the fee to the county. We would have to have some kind of a mechanism for charging a fee.
Can I just ask clarification?
Sure.
I'm proposing that this would be what we would suggest for the legislation. Okay. Not necessarily turn into a regulation. So okay. The legislation would state a fee of $500, or $600, whatever we would think would be that, or what the county commissioners suggest. And then the question is what date would be the appropriate date? Would you think to say there's some clarity, so they would say is that March 1st, should it be February 1st, January 1st, something ahead of the growing cycle? And so then this way, there'd be a clarity like, okay, we need to have our studies done by this time and announce that, you know?
And then that would be something that I could reasonably obtain a very quick response statewide if I knew the scope of work of how many hours each county would need to expend. But I did bring this question up to a handful of agricultural commissioners last week, and 100% of the commissioners told me, until we know the scope of work, we can't give you a number.
So just to get clear, I'm not asking for a number. So that's not what I'm proposing. I'm proposing that a date when they would, every year that they would propose that they would suggest what that number is. So is it February 1? Is it January 1? You know, what would be the appropriate date that they would have that study done by and announce that to the growers versus just leaving it open-ended? Because imagine if they just, some counties just said, well, we're not quite sure, and it's April 15th and they haven't set the fees, and what are growers going to do then? You know, so that's what I'm offering. And then if they don't do anything, then it's a default is $500. And this is would be the recommendation. I'm kind of making a motion essentially, but I'd like to get your feedback, because you're obviously one of the people who are gonna impact.
Well, all county agricultural commissioners are required to submit an annual financial report to California Department of Food and Agriculture on a fiscal year basis, and we have to have that in by October 31st. So, and that outlines all of our program costs and revenue for all of our programs that we administer. So this would be real easy to tie into.
To October 31st?
Yes.
Yeah. And one question is, the first year, would that be, if the legislation doesn't get signed in September, would they need more time that first year, do you think? Is October 31st, like of 2017, is that going to be, or 2018, would that be too much rush with this legislation?
Until we actually have people out doing that work, we wouldn't be able to track the actual hours. So again, when I was talking about a number for a scope of work, for us to come up with a number of an estimate, we would need to get an idea what the scope of work is so we can make a reasonable estimate. But then once we actually do that work, we would have those numbers at the close of each fiscal year of how many program hours we had for each inspection.
Okay.
Perhaps for the first year, we could look to Colorado or Kentucky or another state just for general hours. Josh, just for clarification, is there anything precluding us from moving forward with the registration form in terms of the collection of fees? Do we have to have like the county fee established before we can put forth the form?
So we have to have a fee established. And so at this point, we had the initial motion from the board, which was the $1,000 plus delegating the additional authority of the counties that was determined that we couldn't move forward with that regulation. So we need a new motion from the board saying, here's what we recommend the fee be. And then CDFA would, adjust our regulation package and move forward with rulemaking again. So that way we could move forward with the regular rulemaking process. So that way we could establish that fee. Once we have that in place, then we would be able to, the counties would be able to start registering people.
So we can't delegate to the county ag commissioners under the current language?
Correct.
So it would have to be an overall fee established by the CDFA?
Yes, I mean, the fee could take on almost any structure, but we would have to establish it. So, even if we wanted to say, in some form of a dollar amount or in some method that we say, here's what the fee is, and if we wanted it to be adjusted by county, there would have to be a recommendation on, okay, well, how do we do that? What is the fee structure that we're going to use on a county basis? Is there something that we can reference? I don't know, but we would have to have something that we would actually say, here is what the county fee is, if we wanted to include a county fee.
Otherwise, we would just be operating under
whatever the board recommends as far as the fee. It's very open-ended, but it's open-ended in that it's open-ended in what the board and CDFA can establish. It's just not open-ended in allowing someone else to make those decisions on what the fees are going to be in different places.
So could we establish a fee, but in that recommendation also establish that the county can submit to CDFA to recover their costs involved with that fee?
Yeah, yeah, I mean, we have existing statutory authority just in the Food and Ag Code in general to be able to reimburse the counties. So what we do is we set up an MOU with every county. We do this for a lot of other programs where, we get a registration fee or some sort of a fee from the growers, the counties do work, and then we reimburse the counties for that work. So we'd have to have an MOU with all 58 counties to be able to reimburse them for that work. But yeah, I mean, we certainly could do that and be able to have an overall state fee and then reimburse the counties directly. We do have adequate authority of that. Again, as Rick was mentioning, what gets complicated is trying to reimburse the counties for actual costs. Most of those programs, we just set a statewide amount of here's how much we're going to pay the county for per hour or per acre or per whatever it is for the work. That's not necessarily going to be reimbursing them for actual costs, because as Rick mentioned, your hourly rates range from $42 to $167. For nursery inspections, we give the counties $14 an acre. That doesn't pay for a whole lot. It pays for a small portion of their work, and it's actually more than they got in the 70s. So, but if we want to make sure that the counties are actually recovering full costs, that gets to be a very complicated calculation. So. I mean, again, it's open-ended, and there's a possibility there to set something, but it's just a matter of what does the board want to see that be?
And to add on, excuse me, what Josh had said, an example, the $14 an acre. So what we're not getting in reimbursement for actual costs is backfilled by county general fund. And I would caution the board, I can almost guarantee counties will not enter in, and these are agreements that we have to sign to do that work. We're not required to do that work. But I would caution the board, if there's not full cost recovery, you're not going to get agricultural commissioners to sign these agreements.
Yeah, we do have programs where the amount of money is so little that they would be reimbursed that they just decide not to sign the contract. And so they usually still end up doing the work. It's just paid for out of county funds, because if we're only going to be reimbursing the county, I think we have a minimum reimbursement of $100 for the seed program. And it costs the commissioner more to do their proposal, do the paperwork, and go to the Board of Supervisors for approval than they would be getting for the $100, so they don't even bother. So, I mean, yeah, that's always a concern is that side of it.
So without legislative change, is there a path forward to get a registration form out and go through the rulemaking process where the county ag commissioners would be participating?
So right now, the board can make a recommendation on a registration fee structure, and that's up to the board. It's just we cannot recommend that the counties set their own fees. We cannot delegate that authority. So if the board would like to make a recommendation on a fee structure now to get that process started, the board can do that.
And when you say recommendation, you mean recommendation to the legislature?
No, to CDFA to start the rulemaking process for regulations under current statute.
Which do you think is more appropriate, letting it go under CDFA regulations or legislation?
So right now, we're going to need regulations either way, just to clarify. So we will need to establish a fee under regulation anyway. Even under the proposed legislation, it would just look very different. We wouldn't have to do it for the counties, and we wouldn't be taking county costs into consideration if the counties are able to recover those costs on their own. So it would be a different rulemaking package. Yeah.
Can I make a recommendation? And first I want to sort of summarize what I remember from our past meetings and sort of how we came to this, is that when we set when we recommended the $1,000, that was because we're going to get this money to CDFA, and that was going to help pay for staff, right?
Yes.
But we can also borrow money right now to pay for staff. Am I right?
We currently are.
We currently are borrowing money right now to pay for staff. There's a lot of uncertainty about what these costs are going to be. I would recommend we say we're going to do the $1,000. We're going to allow counties to do cost recovery up to whatever we get from each county. And if we're in the red for a year or two until we figure out what it is, big deal. We're in the red. Let's not make the counties be in the red. And we'll figure out how to, we'll adjust the fees as we go. But we should get this done. We should get this written down and just do it. And it's not going to be perfect, but that's why we're here. We can adjust it next year.
Very good idea. I had a quick question for Josh. if we did have the fee structure in place, would the farmers or the people trying to register, would they be sending their money right to the state of California, or it would go to the counties?
The counties would be collecting those fees, and they would then, the counties are required by law currently to then send those fees to the state. So it'd be kind of a complicated structure where the counties would collect the money, send all the money to CDFA, and then we would have to figure out some sort of a method to reimburse the counties. But that's, I think, more of an internal method. I don't think that's actually done through regulation.
And Rick, there was a worry that the counties may not want to even do that if they feel they might be losing money. Was that the concern? Or they couldn't recover their costs?
I certainly cannot speak for other counties, but I believe the majority of the counties, I know my county would not let me take on a program that's going to have an impact on county general fund.
I mean, just guessing, if we were to say $1,000 fee for farmer, would you expect that you would have to spend more than $1,000 per farmer? I understand that this is a guess, not a.
If you can give me a reasonable number of hours it would take for what we're required to do, I'm guesstimating a couple, 3 hours at the most, depending on what's going to be, and that's based on what we do doing our field walks. We're going to need an advisory that's going to be recommended from this board, and when we get advisories from CDFA as far as how we're going to take the samples, I'm assuming we're going to take one sample, but if you have to go back and take a resample, you're going to have another hour or two and some travel time. So on average, if you said 5 hours, and I think that's on the high side, and the average statewide right now is $84.36, and in 5 hours, that's approximately $400. But there's going to be counties that are $161 an hour, and they can't or won't do that work, because in their case, they're going to be, would be $800 approximately.
So they would still be okay. If they could get $1,000 per farmer, they would be close anyway.
Yeah, for the sake of picking a number, $1,000, but again, we can't charge more than it costs us to do the program either.
Right, and a quick point of clarification. So at the last meeting, we did discuss who would be collecting the sample, and the board did leave that on the table as far as, still needing to be determined who's actually going to be collecting the sample. Is it going to be the lab, the inspector, who?
I just wanted to ask a question on the counties that have the higher fees, $160 an hour. Are those more like San Francisco or Los Angeles, that maybe not be agricultural areas?
Well, not to call out a county, but again, this is a survey that was conducted last year for a completely different program. They did a brief survey, and this was for dealing with Division of Measurement Standards for weights and measures. But the count, and only 30 counties replied. So there may be a couple of counties that are higher than this. But Santa Clara was the highest county in that survey at 161.28.
And what's the next two or three that are high, that are like the next ones that are
They're
high?
going to be more of the urban counties. The way that I've explained it locally is that, the cost of getting a building permit in Santa Barbara is going to be a lot more than getting a building permit up in Redding, California. So,
Okay, so I just wanted to put out for discussion then, realistically, hemp farming isn't going to be, in Santa Clara County, I think they'll maybe be doing hemp farming, clicks, but not hemp farming growing. So instead of raising that fee to try to cover, like $1,000, to try to cover very, urban areas that we're not likely to be growing, maybe we just realize if we set a fee more like $500 or something, or $600, or that's going to cover most of the counties and the ones that are very expensive, otherwise farmers are going to have to be subsidizing, the costs for theoretical potential,
I mean, we need to collect the money for our employees from that $1,000 as well. So, I mean, it's not that it would be subsidizing another county. It would be paying into CDFA and our employees.
Right, okay. And so was 1,000 for 2 years or 1,000 for 1 year?
I think we had said 1,000 for 2.
So the initial motion for CDFA to be able to recover costs was $1,000 for 2 years.
Okay.
But that's just for CDFA costs. That
Right.
would not include county costs,
Yeah.
so it'd be an additional on top of that.
Josh, real quick, and is there any mechanism by which we can adjust that fee and a time frame for that? So if we were to do something like that and then 6 months from now we go, oh, that's just not working, What's the process there?
So if we just made a straight recommendation, it would need to go through rulemaking again. So we would just go back through the process, propose a new fee with the new, data showing why that fee needs to be adjusted, and go through that process again. Obviously, if the legislation goes through and we need to adjust it based off the legislation, that would have to be done in the timeframe set by legislation. But in the meantime, yeah, it's a normal regulation, which, depending on what the process looks like for most programs, is not a terribly long or complex process. But if there's a lot of interest and a lot of debate, it can be quite extensive.
So it sounds like if we were to play it safe to cover costs on the 2-year registration form, per year it'd be $500 for the CDFA and up to $800 for the county. So approximately it'd be $2,500 instead of $1,000 for a 2-year registration.
Potentially, sure.
All right, any other comments on that, for the money involved? Because it seems like we want to get something going, at least, and we can work out the math later, or the reimbursement. Rick?
I guess what would be the issue or the concern with us just charging actual time and mileage? I mean, as we're doing for other programs now, because again, if you have a $40 an hour county, they're going to bill $160 if it's 4 hours. And you're charging $800, so who's holding that money? How do we reimburse that money? People are going to know going into that, once we have a defined scope of work and what our actual role is, we'll be able to give a very reasonable estimate of how many hours it's going to take. And then when we take that item to our Board of Supervisors asking to adopt that fee and charge that fee, we would detail that but based on these provisions and based on our other ag programs, we have a reasonable estimate it's going to take us, for example, 4 hours. Our hourly rate is $60 an hour, for example. We estimate it's going to be $240. But if it takes 3 hours or 5 hours, we charge them accordingly.
Right. Tom, you
Well,
want to
I
say
was just
anything?
listening to Rick. I'm from a farmer standpoint, he would like to know naturally what it was going to cost him to plant his 20 acres or 200 or wherever. And I understand what you're saying. You need to recover your costs, and if you could give him an idea what that's going to be, I think it'd make things move along, with the farmer. I mean, he needs to know what he's going to do. We already set the fee for the CDFA. He knows what that is. You need to recover your costs, but you don't know what they're going to be, but just have some standard fee, and then, like I said, somebody's going to have to subsidize that in the meantime, I guess. You have to budget thing, and then could you annually be reimbursed at the county?
Yeah, and we're annually reimbursed on a number of programs as well, so yes. But for us to put this line item in the budget, I would need to make accurate as I can projections for that. So again, I keep stating this, but if we just have an idea what the scope of work is, I think based on our other agricultural programs, we can make a fairly accurate estimate of how many hours it's going to take us to do that program, and then we just plug in the hourly rate, and we could give our local farmers what they could reasonably expect.
So what if at the state level, we take that 500 a year into consideration, then we take 5 hours of work at the $80 an hour average across the board and make the annual fee $900, so the biannual fee's $1,800, and then, the counties invoice the CDFA for their work, and any excess goes into the hemp fund at the state level.
Basically, that's what would be normally proposed, yeah. And that's more or less how it would work. So I just have one point of clarification for Rick, or maybe two. So first off, as far as reimbursement to the counties, most of the programs that I'm aware of, we just have a flat rate that we reimburse the counties for. Are you aware of any where the MOU has, a different method of reimbursement and how that would work? And is that something that we need to discuss?
For this program, I think we're gonna have to discuss that. Pest
Yeah.
detection is a perfect example. I mean, we've been locked into a rate for how many years now? And the majority, not the majority, but significantly as costs increase, the county general fund's having to pick that program up as a variety of programs. And I can tell you with the side conversations I've had, we're not gonna be taking on another program to where county general fund is having to backfill these programs.
Okay. I think that's it.
And do we necessarily need to identify how that works out between the county and the CDFA to make a proposal on the registration fee itself?
No.
Okay, so we could put a motion forth today to say hypothetically, a biannual registration fee of $1,800 changed from the $1,000.
Yeah. You could.
All right, very good. I think we might be getting somewhere. Just one comment on that. Maybe we might want to, for the first year, just make it for only 1 year, since there's a lot of legislation that might be changing at that point.
Yeah, I think the statute's 2 years, though, in the law, right? SB
Right.
566.
Yeah, so the existing statute requires a 2-year registration and a fee accompanying that 2-year registration. So we can't set an annual fee for a 2-year registration, unfortunately. But yeah, I mean, if there are changes to existing statute, obviously we would have to go back and change the regulation to match those, which should be a fairly simple process.
All right, so where are we at with the number, Matt? Is it 1,800?
I think 1,800 is as low as we can go here on Price is Right.
All right, and I want to go back to Tom. Do you think that's acceptable for a farmer?
For 2 years?
For 2 years, 900 a year?
We talked about, I think I brought this up once before, about whether it's a 10-acre grower or a 1,000-acre grower. Is that the same, I'm assuming?
That's what's being proposed, unless you have any other ideas and want to extend the
I don't know,
conversation.
Well, yeah, well, here's the thing. If somebody's only growing 10 acres, then they can only be growing for CBD. That's just not really going to work for seed or fiber. And if they're growing for CBD, at the moment, they're going to be able to collect a lot more money from the flower than people would for seed or fiber. So it may be workable, even for the smaller farmer, to be able to do this.
My, having been in these meetings for the last almost year now, my feeling from the audience is that they're not really worried about an extra $500 one way or the other if they want to plant seed. And so I think we need to get them a fee schedule so they can do that.
Looking at the fee structures from the 5 states that we contacted before, only one of them, they charge the annual fee of $500, but then they go $5 per acre or 33 cents per 1,000 square feet if you're growing indoors. I mean, do we want to just have our regular fee and then charge per acreage, or just keep it at a regular fee?
My opinion is we keep it as simple as possible, just one fee for growing it, and then people can decide whether it will work for them economically.
And then the annual fee goes from $500 annually up to $1,300 annually.
Yeah, I mean, that's one of the things that we discussed previously. Every state has very, very different fee structures, so it's hard just to model ourselves after a single one. One thing I do want to mention is, I mean, certainly the board can come back to this conversation regularly and decide if they want to adjust the fee structure, if they want to in the future look at acreage fees as they're necessary, or if they want to look at an assessment of some sort once we figure out what's actually being produced by these crops and being sold, and what that would look like as far as being able to recover costs, more equitably. That's something the board can consider in the future as well.
But for the sake of continuing the rulemaking process, we should put forth a motion for a fee today.
If you would like us to propose regulations, then yes, we need a new proposal.
All right, just want to ask Josh, before we make a motion, which I'm about to do, should we hear from the audience or just make the motion first?
It's up to the board. They can make a motion first if they want and then open it up for public comment. If we've got kind of a consensus, that might be a good idea, so that way the public knows what they're commenting on.
Okay, all right, so I think we're at $1,800 for a 2-year fee, $900 a year. All right, so I make a motion that we accept this fee. And
do we have someone making that motion? It sounded like Van was interested in doing it.
Sure. I make a motion that we set a registration fee of $1,800 for biannual registration.
All right, does anyone want to second the motion?
I'll second it.
Go ahead.
John.
All right, John seconded the motion. All right, why don't we have a vote? All in favor?
Oh, hold on, before we go to a vote, let's go to public comment.
All right, does anyone want to make a public comment on the fee of $1,800 for 2 years?
About one, two.
Justin from Seven Generations Producers, it's okay to make some money. So the fees, don't be so concerned about it. I think it's about reimbursing the county and making sure CDFA has money to hire more employees and regulate it. So $100 an acre, $1,800 for unlimited growth. I think that the farmers are gonna appreciate any fee that you set. And I think there's gonna be plenty of money to go around for the next 5 to 10 years. So I think just keep that in mind, is that you're drastically underfunded right now, and this is an opportunity to make some money and be able to pay for the regulation and help guys like Rick and his staff have some additional jobs and maybe actually give these farmers a crop that is gonna have some good value. So don't be so concerned about setting it
Rick
a
said
little
he
bit
can't make
higher.
any money, right, Rick? You can't make money on it.
Cannot make money.
I
I appreciate-
as far as hiring employees, this is about creating jobs and creating an income for the farmer. So that's what I'm saying, is that if you charge these farmers, and this crop particular, you're not treating it like any other crop for a particular reason, it's okay to charge the money. So don't feel bad for charging a little bit of money to make a lot of bit of money.
Thank you, and I don't think the mic had turned on. That was Justin with a comment again, thanks.
Thank you, appreciate it.
Hello, my name is Chad Crivelli. I farm 8,500 acres in Central California, and I'm interested in growing hemp. I also sit on the CDFA Cotton Pest Control Board. I think you gentlemen are on the right track with this, and we assess fees for a pink bollworm eradication program that the counties are in contract with us to do. It's revisited every year. It's an acreage-based fees, acreage change. You know, the cost of doing business for the counties change, and it's something that we reassess every year. And I don't think it's, you know, we're not reinventing the wheel here. These programs are already in place, and I think there's information there, you know, to make the system work. But like I said, I think you guys are on the right track. Have a general fund, reimburse the counties, maybe, you know, pay some in front, and then, you know, have them bill at the end of the year. So thank you for that.
Wayne Richmond, California Hemp Association. Great progress today. I think this is a good move in the right direction, and thank you guys for moving this along today. I would just like to kind of bring up one cautionary thing that comes to my mind, is that when we start taxing the product based on what it's going to become without verification, where is that really coming from? When I go to Home Depot to buy a 2x4, they don't care that I'm building a doghouse, a human house, or I'm going to smack somebody upside the head with it. They're just selling me the part. And I think that when we start telling farmers that, well, we're going to, your crop is more valuable, and so we're going to tax you more, it takes away flexibility for the farmers. And you don't know what the marketplace is like, so I really would caution against trying to split it out like that and just keep it as simple. Generally, like you would do with broccoli or potatoes, because I'm pretty sure you don't tax potatoes on the fact that they get turned into some alcohol down the road, right? So I would just ask for that consideration for our farmers. Thank you.
G.V. Ayers with Gentle Rivers Consulting. Just a question regarding the nature of the, if I may, the nature of the motion and the fee. That is based upon the fee, based upon the code as it is in existing law under the California hemp law. So therefore, if any legislation were enacted which gave counties specific authority to charge a fee, that would be a different issue. And very likely there may need to be additional regulations after that. Obviously would be things from the county. So we're just talking here, you're just talking about with your motion here about what would be done from the CDFA standpoint on the existing law as it currently is. Okay. Yes. Question then also, how quickly would, what's the timeline?
It's a good question. It's the same as it's been, so we've already got the rulemaking package partially drafted. So we'd be making revisions, rerouting it at the department. Hopefully, we would have something posted within a month, month and a half, is what we'd be looking at. But then you have to go through the full rulemaking process. So, we don't know what we're not getting a lot of comments today, but we don't know if that's gonna hold true once we post it out for public comment, and we have to respond to everyone. So we have to complete it within a year, but, hopefully, usually it goes faster. It would just depend on what that public comment period looks like, and if we have to go back out multiple times, depending on if there's any changes.
Then it goes back to what I raised actually about a year ago. Would emergency rulemaking authority for the fees, would that help streamline the process?
Would change the process.
Which,
We still have to do all the same things. So we would put us into the emergency rulemaking process. We would be doing it that way instead. And then after we would complete the emergency rulemaking process, then we would start the regular rulemaking process all over again.
okay. Thank you.
Just for clarification, the comment period was 6 weeks?
Yeah, it's about 6 weeks. It's 45 days is the public comment period. So once we complete our rulemaking package and it goes, it takes a little while to finish review here at the department since we're on a brand new concept here. Then it would go over the Office of Administrative Law. They have 2 weeks to review before it gets posted, and it gets posted on a Friday, whichever Friday it comes out to according to their schedule. Then there's a 45-day public comment period. At the end of that public comment period, we have to respond to every single comment and prepare either any changes or any final statement of reasons. Potentially, if there are changes, we would go out to additional either 45-day or 15-day comment periods. Once we make our way through the entire process, have the final statement of reasons and the final regulation completed and don't have any additional comment periods, then it goes over to the Office of Administrative Law for a final review, which is about another 6 weeks. 30 working days.
Hi, my name is Linda Sawtell. Since other farming practices have different scales of payment based on size, I don't know why this is being treated differently. Why can't somebody with a 100-acre farm versus a 10,000-acre farm or something like that get a graduated process where there's a cap on the top so that they aren't going to pay over a certain amount? But it just doesn't seem fair to lop it all into one group sum when somebody with a much smaller farm, sometimes those kind of fees put smaller farms out of business. And this is California, and we have a lot of craft businesses in many areas. So I'd like you to consider that in this decision, that it doesn't, you do it a lot with other types of crops. Why not put that same kind of thing into effect with this? Thank you.
How's it going? I'm Austin Sherman. I farm hemp in Nevada. In Nevada, they have 3 different licenses: a producer for seed, a grower for the actual plant, and then a processor license. There's 3 separate fees. What's wrong with you guys doing that?
I don't think it's in the law, one thing.
Well, and the board has discretion on how they want to divide out the fees. If you want to make a revised fee structure, a more complicated fee structure. We do have 2 different registrations. So right now, the motion is to set the registration fee the same for both growers for commercial cultivation and for registered seed breeders. As I mentioned earlier, we don't have a license or any kind of mechanisms or rules for manufacturers or processors, so there is no licensing there currently.
All right.
But that's up to the board.
I think the Nevada system's pretty efficient. It works well. I was able to navigate myself through it without a lawyer. So, I mean, something to consider.
Thank you.
All right, do we have any other public comments on the matter? All right, so we have a motion on the table for $1,800 for a 2-year. Why don't we take a vote now on that from the board? All in favor, say aye. Aye. Anyone opposed, say nay. Okay, the motion passes.
Did anyone abstain? No? Okay, just checking. And we do have Valerie is not present, as well as Allison, just to note that.
All right, very good. I think we finally feel like we got something accomplished today, or at least we're moving forward. All right, we have a little bit of time. I think we're now actually, no, we're not ahead. We're a little bit behind. Before we move forward, I think, Tom, you had made you had a question or comment or something earlier in the day you wanted to talk about.
I told you, if I don't ask it right away, I forget.
You
I don't
forget?
remember what that was
Okay.
already. Oh,
All
one
right.
thing,
Yeah.
this, nothing to do with this conversation, but earlier I was thinking about these approved, and I was reading through it, addresses that somewhat in this law, and this legislation, but those varieties that we looked at several meetings ago, that were approved, that could be planted, how did that come about? We didn't hear anything about what the characteristics, or at least I don't remember, of those varieties that were approved. There was a list of them, about 12 or 14 seeds, cultivars, is that right?
You're talking about the currently certified and that CCA has already reviewed. And
Right.
yeah, that'd be a question for Alex, and we can certainly invite him back to have a broader discussion on that at a future meeting.
Actually, I think I remember your question that you had earlier. It was something about maybe making it easier for when people looked at the CDFA website on hemp, that they knew maybe that it was legal to grow industrial hemp. Was that the scope of your question?
No, but I think that's probably a good suggestion. That was, like I said, I have farmers coming to me, and they want to plant this year, and because we couldn't put any an MOU together with a university or college or whatever, never happened. It's already, here we are almost in June, so that planning time that they were looking for, March, April's passed.
As I did manage to look at the website recently, and I did see that there was references to what I think it was references to federal law and the state law on research programs. Michelle, do you want to comment on that a little bit?
That's fine, I can comment. So we mentioned it previously, the board's original, I think it was the board's first motion was for a document clarifying the legal status of industrial hemp, established agricultural research institutions with regards to industrial hemp. So that is posted on the website. But as we're discussing this, I do want to note for the board, and something that we can discuss in the future, but I think it's something that we can kind of open up to everyone, which is that Michelle is working on revising our frequently asked questions that are on the website. So if there are additional things that you would like to see us try to address in those frequently asked questions, she is compiling them from the very many questions that we get from the public. But if there's anything specifically that you'd like to see on the website, you can just feel free to shoot her an email. And that's something that we can probably take care of on our own. But if it's something we need to feel like we need to review and discuss with the board, we can bring that back up in the future as well.
Well, as a farmer, I think the cultural practices would be important. How much water does it take? When are the optimum planting dates? What are the possible sale, the seed for planting, or fiber?
All right, I can help answer that. We at the Hemp Industries Association are putting together right now a farm guide, which I've actually been involved with. And I imagine it will be put together within the next month or two. And I'll be happy to provide that to the California Department of Food and Agriculture if they want to post that on their site.
Some of the other questions I know they asked, planting, spacing, planting between rows, or
Yeah, the farm guide we're putting together is going to be very comprehensive, and it will include fiber crops, seed crop, and flower crops.
Yeah, I mean, that kind of thing might be, Val has already stepped away, but that's also generally a question for cooperative extension. If there's documents or information that you think would be good from like other extension agencies in other states that we could provide out to, additional resources we could provide to the industry, please let us know, and we'll add those links.
Josh, is there anything else hampering the rulemaking process right now that we should consider?
As far as the existing, the motion from today or previous motions?
Yeah, previous motions. I mean, I know we were stalled out here for the collection of fees. Were there any other recommendations from the CDFA that needed to be addressed?
At this point, there's nothing else we need from the board. It's just a matter of staff time and staff doing the work. So I mean, we just need to, keep it going and try to keep, give staff the time to be able to work on it.
All right, moving forward, we just want to ask, are there any additional public comments regarding any of the items discussed at today's meeting? Or are there any public comments on matters that were not on the agenda today?
Hi, Brian Webster, a hemp business person and member of the California Hemp Association. So I just want to clarify, there seems to be a little confusion regarding this industrial hemp being recognized as a California agricultural crop. I just Googled the Prop 64 bill, and I found 44 references to hemp. I found nothing saying that industrial hemp is recognized as a California industrial crop. So, Joshua, is that your understanding, is that industrial hemp is not recognized as a industrial crop in California?
So my understanding is that there's nothing in existing statute that specifies that. So it's just at this point an open-ended question. I mentioned previously, and I was discussing with Matt, that, I mean, there are other opportunities for, noting that industrial hemp is an agricultural crop. I mentioned previously to this board that it's not currently on our list of agricultural seeds. And so, that's something that would theoretically be added. And then again, we would have to apply the seed law to it. But I'm not aware of anything existing in statute that specifies one way or another. And
Okay, so my understanding is that you cannot recommend, motions to this board, but would you have any objection to a motion from this board to insert language into SB 1409 stating very simply that industrial hemp is recognized as a California agricultural crop? Would you have any objection to any motion clarifying that and putting that into, recommending from this board that it be put into legislation?
that would be up to the board to, if they want to make that recommendation.
I think under some of the prior discussion, there was going to be some research into that to see what impacts that might have.
Yeah.
Thank you.
Can we put that on the agenda for next time?
Yeah, sure. Well, so that's the next item, Lawrence, would be. Don't want to steal your thunder.
All right, any other public comments? All right, the last thing on the agenda would be next meeting agenda items, and that would be updates by Joshua.
I actually don't have any updates, so it's whatever. At this point, we'll continue to update the board, and if we have something that we need as far as motions that have already been made, we'll call the board. We'll let Lawrence know and try to bring together a meeting, but it's just a matter of, I know we had one motion from the last meeting that we'll be working on, which is the sampling and testing guidelines that were developed by our sampling and testing task force, and we've been a document together on that, and the board asked that we bring that back to the board, so we would want to schedule a meeting to discuss that. I know we had the question outstanding on the impacts of defining in statute hemp as an ag crop and what that would mean and what that would do. And I don't know if you wanted to appoint somebody to look into that and have a discussion on that in the future. And then Tom, it looks like he stepped away, did have the question regarding what cultivars have already been approved by CCIA and perhaps having an update from Alex on that topic. But that's what's come up so far.
All right, and then regarding the recommendations you made, is there a method that we have where we formally make those recommendations to the legislature?
So we discussed that. I mean, so if the board wanted, and again, we could go back and ask for a motion on that legislation task force report. I don't think a motion is necessary, partly because, as we discussed before, we don't necessarily know what the method would be for us to take a recommendation from the board to the secretary and somehow get that to the legislature, since the secretary can't really make that recommendation to the legislature. However, what they presented today in this conversation is part of the public record already, and the board's conversation is already part of the public record. So that information is already out there. If there was something the board wanted to make a motion on, you're welcome to do it. But I don't know that it's necessary, but if there's something that you certainly wanted to emphasize, that'd be up to the board.
So for example, any one of us is a kind of a citizen and go to the legislature to say, here's what was discussed at the board meeting?
Sure, and we'll be posting the meeting online just as we have with all the other meetings.
Okay, does anyone want to make a motion on that issue at all at this moment? Okay, any other items? All right, I think, look here.
Just for future agenda items, update on the rulemaking process and where that stands.
Yeah.
And probably be, you know, proper timing or scheduling for the next meeting around that.
Yeah.
All right, do we have a date that we feel we want to have another meeting?
Could we maybe send out like a doodle poll? There's so many calendars involved in this. I just think it'd be easier to do it that way.
Just to let everyone know, this auditorium is available for June 22nd, 28th, 29th at the end of the month.
If you want to meet next month, if you wanted to push it back, we could look into dates in July as well.
When do we think we'll get an update regarding regs? Would it be necessary to meet later in June, or would we have anything to discuss?
Well, and that's the question, is how quickly do you want to come back? I think as far as the regulations, like I said, at this point, we have the motion from the board. I don't think the department necessarily needs anything else unless you want to I don't think you want to restart that discussion at this point. You'd like us to move forward with the package. So we'll continue to move forward on that and provide updates as we move forward. But as far as the outstanding questions, as far as the cultivar update, the definition as an ag crop, the being able to present to the board on the sampling and testing guidelines for some sort of recommendation on that. Do you think a month is sure?
Well, yeah, well, I'm thinking we just want to wait until after we hear back from the state whether they accept our recommendations or not.
Yeah.
And, if it goes through, we probably don't even have to meet yet, unless there's some sort of roadblock.
Yeah, other than those existing topics, so if there's an interest in meeting on one of those. But again, if the chair would like to call a meeting in June or July, we can set that date via doodle poll.
I don't think we have to be here every month. I mean, we accomplished the major thing today. That's pretty good. All right, so why don't we maybe make it around the end of July, and you can send a doodle poll, Michelle?
Okay. So check available dates and send out a poll to the board members for the last couple weeks of July.
All right, so without any ado, we will adjourn the meeting. It is 12:42 p.m., and I want to thank everyone for being here and pat ourselves on the back. We're moving forward.
Thank you.